David, in terms of the Rangers situation at the minute, for all employees, what would the situation be transferring from the old co to the new co?
There are a set of regulations called the TUPE regulations, and what they do is they protect the employment of employees in this situation. They do two things. Firstly, they transfer the employment of the employees of the old company to the new company. And secondly, they make sure that the terms and conditions on which the employees transfer are as good as what they enjoyed before. So if a Rangers player was earning £10,000 a week last season, then when they transfer to the new company, they still have a right to their £10,000 a week next season.
How do they go about transferring the employee? How should employers go about transferring the contracts for their employees?
Well, the transfer actually happens by operation of law rather than by agreement, but employers should be consulting with their employees and informing them about the transfer before it takes place. So a normal procedure would be that in the weeks leading up to a transfer, the outgoing employer would tell the employees about the incoming employer and any plans they had for their employees.
Is it conceivable that, given that the assets, i.e. the stadium and the training ground, have already been agreed and the sale has gone through, in that, could there be, in terms of the players and their registrations, gone to the new co as well?
I think that's quite likely, actually. It seems to me that the players would be assigned to what Charles Green's consortium has bought, and therefore it seems to me to be likely that the TUPE regulations might already have transferred their employment to the new company. So
if the players now belong to the new co and players are saying that they have had no communication with the Charles Green consortium, where does that leave them?
They might have a remedy against Rangers for not informing and consulting with them prior to the transfer. They can bring a claim to the Employment Tribunal about that and can potentially claim up to 13 weeks' pay each.
But they would still be employees of the new co Rangers?
They would still be employees of the new co if a TUPE transfer has taken place, yes.
So there's no action to get out of that then?
Employees do have the right to object to their transfer if they don't want to transfer, but that would have to be done before the transfer takes place.
So is this a common thing? Is this something that we see quite a lot?
It's not uncommon at all for transactions to happen at the last minute, and very often an employer will say that we weren't able to consult with our staff because we didn't have time to. In Rangers' case, they might try to argue that the CVA was rejected by HMRC at the last minute, and therefore something then had to be done urgently, and they really didn't have time to conduct a proper consultation with their staff.
Because it's football, does this make the situation a bit cloudier, given that most employees would want to remain in employment and transfer across to NewCo, but when you're dealing with footballers, it's a bit different?
The laws apply the same way, but obviously there's very different considerations for footballers. Your average worker might feel they have no alternative but to transfer to a new company because obviously they want to still have a job, whereas footballers might have other options, and therefore some players might be looking for a way out of this.
People will ask now, and fans will ask, the Rangers players, who are they employed by?
If Charles Green's consortium has indeed bought all of the assets of Rangers, it seems to me that the company that consortium operates is likely to be the employer of the players at this point.
With football regulations and registrations, does that make it a bit more difficult also via the SFA?
Well, football has its own rules about how registrations can be transferred, but the basic point about whether somebody is employed by a particular company or not will be governed by UK employment laws rather than by football regulations.
Are you surprised now that a week or so after the transfer of assets that players have not been informed by members of the consortium?
That does seem strange, yes.
In what way? Why?
Well, as I say, there would normally be an information and consultation process beforehand, and obviously if the identity of your employer has changed, then one might expect your new employer to introduce themselves and to confirm the terms that you're going to be employed on.
And if they're not employees of the new co as it stands, who would they be employees of? The old co?
That's possible. If no TUPE transfer has taken place, then they could still be the employees of the old co. It would appear that the old co wouldn't have any money to pay them at the moment, so it would seem that that would be a pretty short-term relationship from now, if that's the case.
And given that the assets have transferred, then if they are still employees of the old co, TUPE couldn't apply thereafter?
Well, if TUPE applies, they're not employees of the old co anymore. But if TUPE didn't apply for some reason, if there was occasionally in certain types of insolvency situation, TUPE doesn't apply, if that's the situation, then they could still be employees of the old co.
And just to be clear, the only action or the only recourse they can go after in terms of if they are employees and they've not been consulted is 13 weeks.
They can get they can apply to the Employment Tribunal for a claim for failure to inform and consult over the TUPE transfer. The maximum compensation that a tribunal can award for that is 13 weeks pay per employee.
So that could be quite hefty.
In the case of footballers, yes.